Okay, picture this. The internet. It's just massive, right? An open landscape, amazing for information, connection, all that. But, if you're a parent, it can feel a bit like the Wild West sometimes, especially with content for kids. And that's the tension, isn't it? We all want to protect kids from stuff they shouldn't see. But how do we manage that without sort of clamping down on everyone else's freedom online? It's a real balancing act. So today we're going deep. We're unpacking a really recent and frankly a pretty significant Supreme Court decision that tackles this exact issue. It's Free Speech Coalition, Inc. v. Paxton, the Attorney General of Texas, just decided June 27, 2025. And trust me, this ruling, it's got huge implications for how online content gets regulated. It affects you, whether you're a parent just scrolling online or maybe you're just curious about your digital rights. This could really change things.
That's absolutely right. And at the core, you've got this Texas law, HB 1181. Its goal was pretty clear. Try and stop minors from easily stumbling onto sexually explicit websites. So it basically says these commercial sites need to check if visitors are 18 or older. And the Supreme Court, well, they had to wrestle with that fundamental question. How you weigh the state's pretty compelling interest in protecting kids against adults' First Amendment rights to see stuff that's legal for them. And the answer they came up with, well, it's going to echo for quite a while.
Yeah, this case definitely seems to turn on some really core First Amendment ideas. Before we dig into the Texas law itself, maybe just a quick refresher. How does the court usually think about free speech? It's not like anything goes.
Exactly, not a free-for-all. The First Amendment protects speech, but not all speech gets the same level of protection. Think of it as different categories. Some speech gets the highest protection, really hard for the government to touch. But then there are categories of, well, unprotected speech. These get zero First Amendment cover. And for today's chat, the big one is obscenity. But that's defined very, very narrowly for adults using what's called the Miller test. If something meets that specific test, it's not protected.
Okay, and you mentioned this difference, obscene for adults versus obscene for minors. That seems super important here. Why does that give states more room to regulate when kids are involved?
Ah, yes, that's the crucial distinction. It's key. So something might be perfectly legal for an adult to see, not obscene by the Miller standard, but it can still be considered obscene for minors. This idea comes from a really important case, Ginsburg v. New York. It basically acknowledges that, well, kids are different. They're seen as more susceptible to harm, less able to judge certain content critically. So because of that vulnerability, states traditionally get more latitude, more power to restrict kids' access to stuff that's fine for adults. It's about child protection.
Got it. And when the court looks at a law like this, they use these different standards, levels of scrutiny, like hurdles the government has to jump over.
Precisely. Think of them as tests, yeah. Different levels of difficulty for the government to justify its law. There are basically three main ones. First, rational basis review. This is the lowest bar, super easy to pass. It's usually for laws that don't really touch on fundamental rights. The government just needs any plausible reason for the law. Almost anything works.
Okay, the easy one.
Then there's intermediate scrutiny, the middle ground. This applies to laws that might, say, incidentally burden speech or laws based on certain classifications. Here, the government has to show the law serves an important interest. It's not about suppressing speech itself, and it doesn't restrict way more speech than needed. Tougher, but doable.
Right.
And finally, strict scrutiny. This is the Mount Everest of constitutional tests. It's for laws that directly target protected speech based on its content or mess with fundamental rights. The government has to prove the law is the least restrictive means, the absolute most narrowly tailored way to achieve a compelling state interest. This one is, as the court often puts it, almost always fatal, in fact. Very few laws survive this.
Okay, that framework is really helpful. So with that in mind, let's look at the Texas law itself, HB 1181. What exactly did it demand, and what kind of material are we talking about? So the law says commercial websites publishing sexual material harmful to minors have got to verify visitors are 18 plus. And sexual material harmful to minors isn't just anything sexual. It has its own three-part test aimed at kids. First, it has to appeal to the prurient interest of minors, like an unhealthy, morbid curiosity for a kid. Second, it has to show sexual acts or anatomy in a way that's patently offensive for minors. And third, this is key, it has to lack serious literary, artistic, political, or scientific value for minors. And how are sites supposed to check age? The methods are specific, right? Yeah, they mention things like checking a government-issued ID or using transactional data stuff linked to, financial history or maybe employment records. And if sites don't comply, the penalties are steep. We're talking $10,000 a day. Plus, another $250,000 if a minor actually does get access because the site didn't check. That's serious money.
And it's really important context. Like you said, Texas wasn't acting in a vacuum here. This wasn't just some outlier. No, actually, at least 21 other states have put similar online age check laws on the books. So this Texas case, it was really seen as a test case, a potential landmark for this whole trend of trying to apply age restrictions online. States are definitely grappling with this.
Right, so with those requirements and penalties, it's not shocking someone sued. Who brought the challenge and what was their main argument?
No surprise at all. The lawsuit came from groups representing the pornography industry. They're called the petitioners in the case documents. Their argument was pretty straightforward. They claimed HB 1181 was unconstitutional right on its face under the First Amendment. The core issue for them was that the law, by requiring these age checks, unfairly blocked or discouraged adults from accessing speech that is protected for them. They talked about a chilling effect. Essentially, making adults jump through hoops, potentially compromising privacy, would scare them off from viewing legal content.
And the case bounced around the lower courts a bit before hitting the Supreme Court, didn't it? With pretty different outcomes.
Oh, absolutely. A classic sign a case might be heading to the top. First, the district court agreed with the industry groups. They put the law on hold, granted a preliminary injunction, and they applied strict scrutiny, that really tough test. They basically said Texas hadn't proved this was the only way, the least restrictive means, suggesting things like parental filters might work instead. But then the Fifth Circuit Court of Appeals stepped in and completely flipped it. They lifted the injunction, and they used the easiest test, rational basis review. Their take was, essentially, this law is just about keeping stuff that's obscene for kids away from kids. Any hassle for adults, just incidental. That huge disagreement, strict scrutiny versus rational basis, pretty much guaranteed the Supreme Court would need to weigh in and clarify.
Okay, so the stage is set, lower courts disagree, and the Supreme Court takes the case. And they land somewhere in the middle. Applying intermediate scrutiny, that seems to be the big takeaway.
That's exactly it. That's the absolute core of the majority opinion written by Justice Thomas. The court held that HB 1181 requires, and importantly survives, intermediate scrutiny. Their reasoning. The burden it places on adult-protected speech is only incidental. They leaned heavily on the idea that states have always had the power to shield minors from content deemed obscene for them, that Ginsburg case again, and they argued that this power to protect minors necessarily includes the power to demand age verification, especially now online. The court framed age verification as just an ordinary and appropriate means to enforce rules we already accept elsewhere. They drew parallels. You need ID to buy alcohol, right? Or tobacco or firearms. Get a driver's license, lottery tickets, tattoos even. We accept age checks for all those. They even pointed out that physical stores selling adult material often check ID, and that's almost surely constitutional. So the internet shouldn't be different, they argued. Age verification is just a necessary tool to make these protections actually work online.
Okay, but help me understand that incidental effect idea more. Why isn't forcing someone to show ID to see something they have a right to see a direct burden?
That's the subtle but crucial part of their logic. They're saying the law isn't directly aimed at stopping adults from seeing things. Adults can still see it if they verify their age. What the law is directly regulating, in their view, is the unprotected activity, either minors trying to access it or adults trying to access it without verifying. So the hassle for the compliant adult showing ID is just a side effect, an incidental consequence of the state doing its legitimate job protecting kids. They brought up an old case, United States v. O'Brien, about draft card burning. Burning your draft card might be expressive protest, but the law banning destruction of draft cards was about government administration not suppressing the speech. The effect on speech was incidental. So here, they're framing age verification less as a speech regulation and more like conduct regulation, a necessary step, like showing ID at a bar. It's a really significant way to look at it, and definitely a change from how some earlier internet cases were approached.
So that explains why they didn't use strict scrutiny, even though past internet cases often did.
Pretty much. That was a huge point. The majority worried that applying strict scrutiny here would throw all age verification laws into doubt, even the ones for buying beer at the corner store, which everyone accepts. They said strict scrutiny is almost always fatal, and it's not meant for these kinds of traditional, widely accepted regulations. They also made a point of distinguishing this case from earlier ones like Reno or Playboy. Those cases, they argued, dealt with laws that were closer to blanket prohibitions or made it practically impossible for adults to get access, not just laws requiring an age check. Plus, they noted, technology has changed massively since those cases. Today's age verification tools are different, potentially less burdensome than what was available back then. But importantly, they didn't go all the way down to rational basis either. They acknowledged that yes, age checks do place some burden on adults' rights, even if incidental. So it warranted more than the weakest test. Intermediate scrutiny, they felt, was the right fit, deferential but not toothless, as they put it.
Okay, so intermediate scrutiny it is. Why did HB 1181 actually pass that test in the court's view?
Well, they found it met the requirements pretty clearly. First, the government interest. Protecting kids from harmful sexual content. That's universally seen as compelling, let alone important. Check. Second, tailoring. Was the law reasonably designed to achieve that interest? The court said yes. It uses a traditional method age verification adapted for the internet age. And the methods allowed, government ID or transactional data, they saw as legitimate, practical options. They pointed out many sites, including in the adult industry, already use similar systems, as do other age-gated sectors like online gambling or alcohol delivery. They also brushed off some counter-arguments. Intermediate scrutiny doesn't demand perfection. It doesn't have to be the absolute least restrictive means, and it doesn't have to cover every single base. Like, why not social media? Why not search engine? That kind of under-inclusiveness is okay under this standard, and privacy concerns. The court basically said websites have business reasons to protect data, and these methods are already in use. They seemed less worried about that than the challengers were.
But it wasn't a unanimous vote, right?
Oh, yeah.
There was a dissent. That's often where you see some really interesting alternative takes. What did the dissenting justices argue?
Right. Justices Kagan, Sotomayor, and Jackson disagreed strongly. Justice Kagan wrote the dissent, and she argued forcefully that strict scrutiny was absolutely the right test to use here. Her starting point was that HB 1181 is a quintessential content-based law. Why? Because it singles out speech based on its message, its communicative content specifically, sexual material harmful to minors. And crucially, she stressed, material that's harmful for minors is very often constitutionally protected for adults. HB 1181, she argued, directly impedes adults trying to access that protected speech. The dissent was much more concerned about the chilling effect. They thought the hassle and, significantly, the privacy risks of handing over ID or financial data would definitely deter adults from viewing lawful content. Plus, the cost for websites to implement these systems also burden expression, they noted. The dissent really leaned on precedent those earlier cases like Sable, Reno, Playboy, Ashcroft. They saw a consistent line. When a law restricts adult access to sexually explicit material to protect kids, the court always applied strict scrutiny. And for them, it didn't matter if it was a total ban or just a burden like age verification. If it's content-based and burdens protected speech, it gets strict scrutiny, period. They directly pushed back on the majority's reasoning. That O'Brien draft card analogy, misplaced, they said. This law is about the speech itself, not just conduct incidental to it. And the majority's idea that the right to view this content comes with an inherent age check requirement. Justice Kagan called that circular reasoning a gerrymander of the First Amendment. Yes, technology changes, the dissent acknowledged, but fundamental First Amendment principles don't. Tech changes might affect how you apply strict scrutiny, like what Town says, least restrictive, but not whether you apply it. Interestingly, the dissent didn't say age verification could never be constitutional. They thought a well-designed law might survive strict scrutiny, given the compelling interest. But strict scrutiny would force the state to prove it chose the least restrictive option if other effective methods exist. By using intermediate scrutiny, the dissent warned, the majority avoided asking those tough questions about the law's potential overreach, like how broadly sexual material applies or privacy safeguards.
Okay, so bringing it back to our listeners, what does this ruling actually mean for you, browsing the internet, maybe raising a family? What's the practical impact? Well, first off, if you're an adult wanting to access certain kinds of sexually explicit content online, your right to do so now officially comes with this court-approved hurdle. You'll likely have to verify your age more often. That's a definite change. Previous big rulings tended to push back harder against these kinds of requirements. So expect more age gates, more consistently enforced. Second, those verification methods, government ID, transactional data, they do raise real privacy questions for a lot of us. The court might have downplayed them, but for you personally, it means thinking about that trade-off. Access versus sharing potentially sensitive data online. How comfortable are you with that exchange? Now, flip side, if you're a parent, this ruling is a pretty big green light for states trying to shield kids online. It basically validates the idea that those traditional child protection efforts can and should be updated for the digital world. So states now have a clear legal path to enact these kinds of laws, which might offer some peace of mind for families trying to manage kids' internet access. And lastly, looking bigger picture, This sets a major precedent. We already have, 21 states with similar laws? This could easily encourage more states to follow suit. And maybe, just maybe, it could influence how other types of online content get regulated down the road, not just sexually explicit stuff. This could have ripples across the whole internet landscape. So yeah, that's the essence of it. The Supreme Court took a middle road, using intermediate scrutiny for Texas's age check law. They decided it's a constitutional way for states to protect kids, even with that incidental burden on adults. It's a complex decision, and it's going to affect everyone online, one way or another.
Absolutely. And as the internet just keeps changing, keeps evolving so fast, this deep dive really highlights that ongoing push and pull, doesn't it? Between the government's power, its duty really, to protect vulnerable people, especially kids, and our individual freedoms, freedom to access information, freedom of expression. This ruling just shows us again that the line between those two is always being debated, always being redrawn. And where that line falls has profound consequences for how we live our digital lives. It really asks, what price in terms of friction or data are we willing to pay for that protection?
Exactly. It's a profound question. This decision forces us all to think about that balance the court tried to strike. And what's the long-term effect going to be on the internet we all use, for adults and for kids? Will it genuinely make things safer, or just more walled off? I guess only time will really tell how this legal shift plays out day-to-day online. Thanks for digging into this with us today.